Hello. Here is Group 2 in our Deliverable 3. The team members in this group include Ashley Klepper, Bo Browning, Damaris Feliciano, and Mohammed Dubraka. Today, our team will discuss the case of CDKL Mart and Fatima Hamid. Through this presentation, I hope you are able to see how our team ultimately got to the decision that we did.
The issues. The issue regarding this case asks this question: did CDKL Mart wrongfully terminate the employment of Fatima Hamid, formerly known as Felicia Johnson? And can a company legally enforce their employment rules and guidelines specifically regarding the dress code when an employee is exercising her First Amendment rights? Facts for the issue. Felicia Johnson, 24, was hired by CDKL Mart in 2012. At the time of her employment, she executed an employment agreement which stipulates rules and regulations through the employee handbook, including a dress code policy that requires a mandatory uniform. The dress code policy Johnson agreed to states no exceptions would be made to the policy. Her supervisor advised her that this attire was not in accordance with the uniform policy and to remove the garment. Fatima refused to remove the item. She was denied to work that day and sat in the customers section, but was clocked in on her time card. Fatima reported to work every day for 3 days, continually refusing to remove the head garment. On August 25th, Fatima Hamid's employment was terminated due to insubordination and violation of company uniform policy. Facts against the issue. As of June 2016, Fatima has been an outstanding employee who has been at CDKL Mart for 4 years. On July 2016, she met her future husband, Abdullah Hamid, and then married him 1 month later. She changed her name to Fatima Hamid and converted to Islam upon marriage to Abdullah. On August 22, 2016, Fatima Hamid reported to work wearing a religious niqab, which is a Muslim headdress that covers a large portion of her face. However, she did wear the company's required employee t-shirt, along with a long skirt.
Now that we have some facts for and against our issue, we can get some relevant laws and regulations. These will prove to explain our side of this topic and why we ultimately got to the decision we did in regarding this case.
First and foremost, Fatima is bound by the First Amendment in the U.S. Constitution. Specifically, she is protected by the Freedom of Religious Clause. Fatima has every right to express her religion freely. Another defense for Fatima is the Free Exercise Clause of the First Amendment. This clause requires a public employer to accommodate an employee's religious observance or practice. CDKL is obligated to accommodate Fatima and find the solution that worked best for both parties. In addition to those defenses, Title VII of the Civil Rights Act of 1964 applies. This defends all aspects of religious adherence, practice, and belief, and outlines religion very broadly. Additionally, Title VII entails an employer, once it is aware that a religious accommodation is required, to provide accommodations for an employee who has openly held religious belief, practice, or adherence clashes with a work requirement, except if doing so will pose an undue hardship. Therefore, when an employer's dress and grooming policy or preference struggles with an employee's recognized religious belief or practices, the employer must take an exclusion to allow the religious practice unless that would undo hardship on the process of the employer's business. As a team, our final decision came down to this. Felicia Johnson exercised her rights when she was married to her husband Abdullah Ahmed and changed her maiden name to her maiden name Fatima Ahmed, which is perfectly legal. Fatima also exercised her religious rights to convert to Islam. By doing so, followed her religious beliefs and wear the niqab. Companies must follow the laws set forth regarding religious accommodations. Finding for the plaintiff, Fatima Ahmed.
Upon viewing the issue at hand, the decision made in terminating Fatima Hamid was in fact unjust. Based on the laws and facts referenced, we were able to come to this final decision. Fatima exercised her right as an American to get married. Under the First Amendment in the Constitution, she also exercised her right to freedom of religion. Changing her religious beliefs and her name were rights Fatima had as an American citizen. Unless it would be an undue hardship on the employer's operation of its business, an employer must reasonably accommodate an employee's religious beliefs or practices. This applies not only to schedule changes or leave for religious observances, but also to such things such as dress or grooming practices that an employee has for religious reasons. With CDK Elmart having 10,000 units in all 50 states, they should have been very familiar with this law, especially considering the wide variety of race, religion, and gender acceptance the company states they have. With that said, Fatima wearing both the niqab and skirt would not have caused any undue hardship to CDK Elmart's operation of business. Fatima simply made an addition to her uniform by wearing the niqab. She was in no form a hardship. Fatima still chose to wear the company uniform shirt, which would make her identifiable to all guests at the store as an employee. She never decided to not wear a uniform altogether. In addition, this change in her religious beliefs would also have not affected her work ethic. She was a great employee for over 4 years. By her changing attire and religious beliefs would not make her any less an employee than she was. Both ethically and legally, a company cannot terminate a person under the circumstances CDK Mart did to Fatima. Fatima's employer must respect and accept her newfound religious beliefs, as she is not a disruption to the store. In fact, she was viewed as a 4-year-long asset to the company previous to this incident.
Our group has many opinions on what CDKL Mart could have done differently. Jack and Olivia could have most definitely avoided this situation. If they could have followed these steps, things could have gone differently. First and foremost, defendants should have allowed an exception to the dress code as religious accommodation under Title VII of the Civil Rights Act of 1964. Defendant Brown and Moore could have offered plaintiff Hamid an exception to the dress code by allowing her to dress in the company colors or by wearing an identification badge that indicates she works at the store. Customer would then be able to easily identify that she is a CDKL Mart employee while adhering to her religious practices. In order to ensure the situation doesn't happen to CDKL Mart in the future, management must take case-by-case determination of any needed religious exceptions. Even if the employee or applicant does not formally request a reasonable accommodation, CDKL Mart must make a reasonable accommodation or an exception to the dress code policy. CDKL Mart can add a section to their dress code policy that states the accommodations that were suggested in the previous section. The accommodation may include religious garbs that match the company colors or wear an official CDKL Mart identification badge that indicates that they are CDKL Mart employees. By implementing this policy to the dress code, CDKL Mart can avoid any problems like this from occurring in the future. We as a group hope that you enjoyed the presentation today. Based on the facts and research we conducted as a team, we hope you were able to understand why we ultimately came to the decision we did. With that said, here are the references that assisted with us coming to our final decision. Thank you from all of us in Group 2.